So just briefly, I want to just speak to those of you who don't know your work, that you are a full professor at the Faculty of Law in the University of Toronto, which you joined in 2006, that Professor Fadel has wrote his PhD dissertation on legal process in medieval Islamic law at the University of Chicago. And he's also got a JD, I suppose that's a legal qualification, right? From the University of Virginia School of Law. I think that's probably the first time we met many, many years ago.
Yes.
In the 1990s. And you've done some interesting work, in law on transactions and securities related regulatory investigations. I found quite interesting that you shared with us. But today you're going to talk to us on this paper on paternity, Maqa, and DNA. So thank you very much, and I hand over to you.
Well, thank you very much, Professor Tayyib. It's my great pleasure and honor to be with you today. I wrote this paper in connection with a workshop that was organized at Georgetown University in Qatar a couple of years ago. A lot of great papers were presented there, and inshallah, the papers will be published soon, we're hoping, in Hawa. And so, there's just a long line of articles that have to get through before these papers come through. But if you're interested in the published version of this paper, it should be coming out in Hawa along with other articles about modern reproductive technologies and Muslim societies. But otherwise, you can see the draft paper if you haven't already. A link to it is available on my SSRN page. And it's more or less how the final paper, I suspect, will end up. Okay, so if you allow me, I will now share my screen. I prepared a PowerPoint slide presentation. So let me go to that. And if I could just confirm that everybody can see that. Does it, Abdul Qadir?
Yes, I can see that. So I think that everybody else can.
Okay, so what I wanted to do in this paper is look at a new technology, a new source of empirical information, DNA, and then try to determine how Islamic law as a normative matter should respond to the potential existence of a new source of knowledge which did not exist in the Middle Ages. Now, this is a good case to think about, because many situations in which people use maqasid al-sharia kind of reasoning rest especially on this notion of changed circumstances. And so changed circumstances require an adjustment in the rule, and that's a perfectly orthodox legal principle, right? So if you look at medieval legal theory and they say, well, wherever the rule is based on a particular fact and that fact changes, then the rule has to change. And that's not even ijtihad, right? That's just following the old rule. It's just that the new fact has changed, the sabab has changed, so to speak, and so therefore the conclusion has to change. Now, a lot of people, I think, reflexively assume that because DNA exists, many of the formal rules that exist in pre-Islamic law, pre-modern Islamic law for affiliating fathers to children should be revised, because the assumption is simply that these rules are proxies or second best approximation for what's really the desired goal, namely identifying the child with the biological father. So what I'm trying to do in this paper is test that premise by looking at a variety of sources and a variety of rules and trying to determine whether in fact jurists understood biological truth to be the highest value in affiliation, right? Now, that doesn't mean that you can accept their balance of reasons and their balance of values. But what I'm trying to show is how you can have a completely rational conception of rules of affiliation that don't necessarily prioritize biological descent. And that's ultimately what I'm going to argue, that if you take a broad maqasidi view of the rules of affiliation, the only conclusion is that biological descent is one value, but it's not the only value. And in most cases, it's subordinate to another value, namely the well-being of the child. Okay, so with that introduction, let me begin. Why is this not moving? Okay, so what are the maqasid al-Sharia? I'll just go through this very quickly. I assume this is familiar to most everyone in this audience. Well, there are 5. These are deemed to be universal interests of humanity. They call them al-kulliyatul khams, protecting religion, protecting life, protecting progeny, protecting rational capacity, and protecting property. Now, appeal to maqasid has become ubiquitous in modern Islamic discourse. And this is true whether the author is a reformist or very conservative. So it's a very appealing type of theory of Islamic law, and it's also very flexible. So one used to think, or one might have thought, that maqasid is purely something that reformers are interested in using, but in fact also very conservative theologians are also interested in using maqasid to justify resistance to change. Now, where do we get okay, what are the sources of the maqasid? Well, the maqasid are derived from an inductive reading of Revelation, right? So depending on the jurist, well, all the jurists would agree that you only determine maqasid by reading Revelation, so Quran, Sunnah, and consensus. But there's also other jurists like Shatibi who say that you also have to do an inductive reading of the positive rules of fiqh, right? Which makes sense because the positive rules of fiqh specify more abstract principles that are found in Revelation. But the crucial point about maqasid is a theological one, namely that there is a rational relationship between the revealed law and human flourishing, salah, or well-being. Now, I prefer to translate salah as flourishing rather than interest. And in doing so, that's based on the idea, that the substantive rules of Islamic law are not subjective. They don't determine, or they don't turn on the individual's subjective perception of flourishing, right? Rather, the theory of maqasid is based on an objective perspective on what constitutes true human flourishing. For this reason, Shatibi has a very long discussion in Muwafaqat that distinguishes between what he calls manfa'ah, which we might translate more properly as interest, and maslaha. So manfa'ah is something that is desirable in relation to a particular person. It's a subjective feeling of wellness, so to speak. But he says that's not what I mean by saying maslaha. It's not what the Sharia means by maslaha. It's rather sort of our true well-being and happiness, regardless of our subjective perception of it at any particular time. Okay, so let's turn to the basic question, the rules of paternity. So the asl, the principal text organizing the rules here are in Ahazab 33, 4 through 5. God did not make those whom you call your sons, your actual sons. That is merely an expression of your tongues. But God speaks the truth and he guides to the correct way. Attribute them to their fathers. That is more just in the eyes of God. But if you know not their fathers, then they are your brothers in faith and your dependents. Right? So what does this text do? Well, the first thing is it abrogates the pre-Islamic Arabian practice of adoption. It distinguishes between those whom a man might call his son, da'i, from his actual son, ibn. Second, it commands us to affiliate sons, and by analogy daughters, to their fathers, right? And declares that this is the rule that justice demands. Third, it says if you don't know the child's father, then the child is a brother in your religion and entitled to the care of the Muslim community. Finally, the concluding clause of the verse absolves individuals from liability for unintentional but mistaken attributions of paternity. Now, presumptively, fathers here means biological fathers, because that would be the ordinary linguistic sense of the word. And again, in rules of interpretation, we are supposed to interpret words in their ordinary sense unless there's some kind of circumstantial evidence, qarina, that indicates a particular sense, like a shari meaning to the word. And here in this verse, there's nothing that suggests that. Now, I would like to point out that there's nothing in this verse that conditions affiliation of a father to a child to illicit relationship with the mother of the child, right? The plain sense of the verb is simply that children should be affiliated to their biological fathers and no one else, provided that the identity of the father is known. So I would say that that's the default rule, the background rule, the principle, the asl, is you attribute children to the biological fathers if you know them, okay? Without any kind of prerequisite that the father have some sort of licit relationship with the mother. However, there is an exception to this because there is a second text, namely, al-waladu lil-firash wa lil-ahiri al-hajar. The child belongs to the legitimate bed and the male adulterer receives nothing, okay? So the second rule is that the male adulterer, even if you know him to be the child's biological father, is not entitled to any paternal rights, right? This is based on a hadith attributed to Prophet Muhammad. According to that report, when the Muslims returned to Mecca triumphantly, the Prophet's companion Sa'ad ibn Abi Waqqas claimed custody of a child of an enslaved female that belonged to a man named Zam'a. Sa'ad claimed that his deceased brother, Utbah, told him that the child was his, and he entrusted Sa'ad to take the child and care for it. Another man, identified in the report as Abd ibn Zam'a, claimed that the child was his brother. Abd based his right to take custody of the child on the fact that the child's mother was a slave that belonged to his deceased father, Zam'a, and that accordingly the child was born on his father's bed. The Prophet ruled in this case in favor of Abd and was said to have declared the child belongs to the legitimate bed and the adulterer receives nothing. Okay. The third text comes in a ziyada, as they say, or an addition to this previous report, which is narrated by Aisha. In some of the versions of this report, Aisha then says, after the Prophet made his ruling, she added, the Prophet then said to Sauda bint Zam'a, the sister of Abd and the putative sister of the child whose paternity was the subject of the dispute, conceal yourself from him, i.e. the child. Ihtajibi minhu, right? This was because of the resemblance that the Prophet noticed between the child and Utbah ibn Abi Waqqas. Although Sauda was, from a legal perspective, the boy's half-sister, both of them sharing the same father, Zam'a, the Prophet nevertheless ordered her to treat him as a stranger with respect to rules of modesty on account of the manifest resemblance between the child and Utbah, the male adulterer in this case. The implied principle, therefore, is that biological descent, while not dispositive of paternity, might nevertheless have secondary legal consequences. In this case, that meant that Sauda, the child's legal sister, should nevertheless observe the norms of dress that apply between unrelated males and females whenever she was in her presence. Such a rule implies that ordinarily applicable rules, which demarcate the boundaries of appropriate appearance and behavior separating the intimacy of the family from the public world of strangers, do not apply when legal siblings are not, in fact, biologically siblings. By way of analogy, the rule communicated to Sauda to observe the rules of dress related to strangers in the boy's presence implies that bars to marriage too follow biological relationships, not legal rules of affiliation. So let's summarize the rules of affiliation. Basically, you can take it in this juristic maxim, ma'u zina or ma'u zani muhdar, meaning the sperm of the adulterer is given no legal standing, right? So that means if the child was conceived through illicit intercourse and the mother was unmarried, the child could be affiliated only to its mother, even if the biological father subsequently married the mother or came to own the mother if the mother was a slave. If the child was born in an illicit relationship, in other words, if the mother was married or a concubine, the child is presumed to have been conceived through illicit intercourse, right? Subject only to the husband's right to repudiate paternity through a procedure known as la'an, or the master's prerogative to repudiate paternity through another procedure, right? The only significant dissenters from this rule are the iconoclastic Syrian Hanbali jurists Ibn Taymiyyah and Ibn Qayyim, each of whom argued that the illegitimate child should be affiliated to the biological father if known, either because the prophetic ruling al-walad al-firash doesn't apply to an unmarried woman, or because the illegitimate child is equally the offspring of the male and the female adulterer, so it is arbitrary to affiliate the child to the adulteress but not the adulterer, at least in circumstances where no other male claims paternity. Okay, the fourth text I want to consider is La'an, right? And that's in An-Nur 24:6. As for those who accuse their wives of adultery, but whose only witnesses are themselves, they may testify against them by swearing 4 oaths by God that they are telling the truth. Okay. Now, as a preliminary matter, a husband is not allowed to accuse his wife of adultery based merely on suspicion that she committed adultery, but must rather claim to have witnessed actual penetration, right? Now, just by way of caveat, the texts I'm going to rely on are almost entirely from the Maliki school. So I don't know what Hanafis say or Shafi'is say, or Hanbalis for that matter, or the Shia. So I guess you can take that for what it's worth, right? So the Malikis insist that a husband, in order to accuse his wife of adultery, must claim that he witnessed the act of adultery. The early Maliki jurist Ibn al-Qasim was reported to have stated that a husband who accused his wife of adultery, but admitted only to seeing her naked with another man, under the sheets or whatever, but did not witness the act of penetration, was guilty of slander and could not proceed with the La'an procedure. Furthermore, even if the husband claims to have witnessed actual penetration, La'an only results in repudiation of the child if the child is born within 6 months after the date of the alleged adultery, or the husband claims that he had not had sexual relations with his wife between the time of her last menstrual period and the time of the adultery. The Malikis also recognize a second ground by which the husband can use the La'an procedure to repudiate affiliation, and that's when he repudiates based on pregnancy. The husband does not claim to have witnessed adultery, but he claims that the pregnancy could not have been from him. Where the husband wishes to repudiate his wife's pregnancy, he must assert that he had refrained from sexual relations with her prior to her pregnancy, such that it would have been impossible for him to be the biological father, right? In the absence of a formal accusation of adultery, however, any children born to his wife are affiliated to him, even if, for example, he had been away on a journey for 10 years and several children were born in the interval. Implausibly long gestational periods also work to affiliate children born to a widow or to her deceased husband for potentially years after the husband's death, right? So I summarize these in the slide. A husband may formally accuse his wife of adultery and thereby repudiate his child, but only if, 1, he witnessed her adultery and immediately ceases further sexual relations with her, and the child is born at least 6 months thereafter, or he claims that he had not had intercourse with the mother since her most recent menstrual period, or in the case of pregnancy, he brings the action immediately upon discovering that she is pregnant, and claims he had not had intercourse with her in the 6 months prior to her pregnancy. So finally, this is kind of recommendation, since we're speaking about sort of supererogatory rules. The Malikis counsel a husband who witnesses his wife committing adultery to conceal it and not bring an action, right? It's preferable to conceal even if you witness the adultery. I think even I was looking recently at a Shafi'i text, and the same rule is mentioned, saying that if the husband witnesses his wife committing adultery, it's better for him simply to divorce her, not to bring a li'an action. Okay, so then finally, though, however, according to the Malikis, if he is certain that it's not his child, he's obliged to bring a li'an action. Okay, so what maqasid are at stake in all these various rules that I've set out? Is it biological descent or the well-being of children? That's what I'm suggesting are the two principal values at stake, right? So ideally, legal patrilineal descent ought to overlap entirely with the facts of biological paternity. Right? If everybody is behaving the way they're supposed to behave, there wouldn't be an issue. But of course, that's not the real world, right? Now, in my view, the only way to understand these different rules is to understand that priority is given to legal conclusions regarding affiliation over biological facts of affiliation, except in extremely narrow circumstances, right? Now, the reason, the reason, I guess the problematic rule here is the status of the free woman, which I'll get to later. But I think one way to understand the rule about not allowing the adulterer to be affiliated to the illegitimate child is that it worked in the reasoning of the pre-modern jurists as a kind of deterrence to deter men from engaging in illicit intercourse with unmarried women, because they would receive no benefit from that. The child would be forever barred from being their child. And as one jurist said, the revealed law interdicted the child's affiliation to the fornicating adulterous father. Al-Shari qata'a nasabahu an az-zani. So contrary to modern intuitions, jurists understand this rules as a deterrent to illicit intercourse, not as a tool of disciplining women. So Muslim jurists, as exemplified by the comments of Fakhruddin al-Razi, stress the danger of adultery to the well-being of children. The sexual exclusivity, ikhtisas, between the mother and the legal father, it was argued, encouraged men to take care of the children born to their wives. So one response to this threat of adultery, perhaps counterintuitive, is to take a don't ask, don't tell approach to the bona fides of the births of children born in illicit relationships. By doing so, Muslim jurists must have believed they were affirming rules that ensured that children would have a legal father who could be held accountable for the child's material and psychological needs. Therefore, ex post, you have very narrow grounds on which a father can repudiate a child born to his illicit sexual partner, whether a wife or a concubine, right? So ex ante, the adulterous male can never claim paternal rights. Ex post, his ability to repudiate is extremely narrow, right? And I think the reason for that, as I said, is the well-being of the child from different perspectives, ex ante and ex post. Ex ante, to minimize the number of illegitimate children. Ex post, to minimize the number of children whose settled relationships could be undermined by actual evidence of adultery, right? At the same time, they were willing to give effect to biological paternity in other areas of the law, for example, in incest bars, relying on the principle of khalt al-ansab, right? But before I get there, from the ex ante perspective, of course, there were numerous rules. I'm sure we're familiar with many of them that were intended to prevent illicit intercourse from taking place and to preserve a close connection between law and biology. For example, the rule of observing iddah after divorce and widowhood, and the man's duty to observe istibra in situations where a woman might be pregnant from another man, right? Likewise, rules discouraging gender mixing serve the same purpose, namely to reduce the ex ante risk of illicit intercourse and the chance that legal paternity would not overlap with biological paternity, right? The same desire for the well-being of the children is reflected in the narrow rules of la'an, right? According to Malik, again, if a husband only witnesses his wife's adultery, he is discouraged from bringing a la'an procedure. But if he knows that he is not responsible for his pregnancy, he is under an obligation to initiate the proceeding. Then with respect to this last point, again, we have that in the hadith, or Aisha's comment on Aisha's ziyada on the hadith, that the Prophet told Sauda to observe hijab when in the presence of her half-brother, right? And then finally, of course, we have the value of protection of public reputation for good character, Seth, as we see in the rule, the recommendation to husbands not to bring la'an procedures, even if they witness their wife engaged in adultery. Right? Now, the biggest problem here, in my explanation, is, what about the illegitimate child of the free woman, which is by far in the worst situation? So in the pre-modern doctrine, the illegitimate child of a free woman could never have a legal father. It could have, however, a kafil. Kafala is a second best solution, and it has its own problems, right? And because of the difficulty of the illegitimate child of the free woman, right, we're pretty confident that they faced the risks of severe trauma, either being aborted, killed, or abandoned on birth, right? It's impossible for us to determine how frequent this took place in pre-modern Islamic societies, but I'm sure it took place, right? The problematic treatment of the illegitimate child of the free woman might be because jurists believed that the well-being of children generally was better served by minimizing the incidence of illicit sexual relations with unmarried women, and that an easy way to do this was to prohibit men from benefiting from illicit intercourse. On the other hand, it might be a situation that they didn't give much thought to it if it was relatively rare. While early figures such as Malik contemplate the possibility that the free woman might have an illegitimate child, it might very well have been the case that they associated this as a problem primarily with slave women. That adultery was associated primarily with slaves and possibly even prostitution is tangentially confirmed by a report in which Hind bint Utbah, when she pledged loyalty to the Prophet Muhammad, expressed surprise that the pledge included a commitment to refrain from adultery, saying, does a free woman commit adultery? See, for example, Al-Muwatta 3:746. Whatever its limitations, the predominant value involved in kafala was the well-being of the child. It vindicates the concerns of the jurists that we argue explain their reticence to undermine established paternal relationships, even when such relationships were far-fetched. But kafala is an imperfect substitute for a parent. Unlike the parent-child relationship, which involves indissoluble reciprocal rights and obligations, the kafil, which we can translate as foster parent, never has prospective legal obligations toward the child. Nor does the child have any legal obligations to the foster parent upon becoming an adult. From a legal perspective, the kafil is purely a volunteer, and at any time he can walk away from his responsibilities to the child. Likewise, the child has no duties to the caregiver upon becoming an adult. So it's not surprising that jurists were under some kind of pressure to transform the foster relationship into something more stable. This manifested itself most clearly in Hanafi doctrine, where the foster parent was permitted, the foster father was permitted to claim the child was his without proof of paternity. The Hanafis justified this rule by istihsan, noting the need of the child for affiliation to a father and the need of the father for a child. Now, ironically, the child of a slave is comparatively better off, at least, I'm saying a lot less vulnerable than the illegitimate child of a free woman. Either he will be affiliated to the mother's master through ownership if the master denies paternity, or if he admits paternity, then he will be manumitted. He will be free upon birth, because the mother is the walad of the father, right? So this is one case, I think, where it's worse off being a free person than a slave. Anyway, now the question is, should the ready availability of DNA evidence change these historical rules? Well, I think pre-modern jurists were well aware that formal rules of affiliation did not match up 100% with biological facts of descent. However, as I argue, historical rules are not just a consequence of limitations of knowledge available to establish biological paternity, but also the legal determination that some values are more important than knowledge of true facts. such as the well-being of the child. But this suggests that there might be limited applications for admitting DNA, right? The best case would be for children born to an unwed mother, right? Here, though, we have to be careful. We might be able to distinguish between biological parent fatherhood and legal fatherhood. In other words, we might establish a rule that says the biological father is monetarily liable for the costs of the child, but is not entitled to any of the benefits of paternity in light of the fact that the Prophet said that the adulterer should get nothing, right? So you could say the hadith does not preclude liability, it just precludes benefit. So if we can identify the adulterer's father responsible for the illegitimate child, we could hold him responsible, but not give him any of the benefits of the unlawful act, right? On the other hand, the worst case for the use of DNA evidence would be to challenge already existing legitimate paternity on the grounds that the pregnancy was the result of adultery, right? So this kind of, I would say the logic of pre-modern Islamic law would suggest that DNA evidence could only be admissible to challenge a pre-existing relationship, i.e. in the context of a married woman, right? If the husband satisfies the procedural requirements for doing a la'an procedure, namely, he witnessed the adultery with his own eyes, and he immediately refrained from further sexual relations with the wife, and he had not engaged with sexual relations with her since the time of her last menstruation up to the point of the adultery, right? Or he satisfies the conditions required to show that his his responsibility for the pregnancy was impossible. But what's clearly not permissible is for the man to wait until the woman gives birth to the child and then decide, oh, I don't think this child is mine, therefore I want to bring DNA evidence to exclude my responsibility. So that concludes my, finally, sorry, one last point. There might be a middle case used for DNA evidence on the wildly unrealistic assumption that we could trust governments with this kind of data, but we could use DNA evidence to make sure that people are not unknowingly marrying within prohibited degrees of kinship. Now, this might not be a huge problem in Muslim societies. The chances of somebody accidentally marrying an illegitimate brother or sister or child seems extremely low and remote in the Muslim world. I don't know. But actually, this is a real problem in countries like the United States because of things like sperm donations. So you have people who are or men who are the biological father of hundreds of kids, none of them knowing who their biological father is. And there actually have been cases where they have met each other and attempted to get married, right? So this could be another use of DNA evidence, having some kind of, in theory, DNA bank so when people get married, it would be tested against it to confirm that they are not biologically related in any kind of unlawful way. But again, as I said, given our suspicion of how governments would use this data, that seems to be extremely problematic. Okay, thank you very much for your attention, and I look forward to your questions.
So thank you very much, Mohammad. I think that you've given us both from the paper and listening to you again, helped me to think about, on the one hand, I think you've given us a sort of a reading of the maqasid, taking us through these, 4 texts that you presented to us, and also the juridical rulings that were based on these texts. So I think in a way you've given us 2 things, 2 very valuable, reflections on thinking about the maqasid through, reading inductively through these texts and suggesting some maqasid. And secondly, what are the possibilities and how do these, can these be applied with DNA testing? I will ask, people just to indicate to me that you want to ask a question. You can either just indicate that to me in a chat, or you can use raising of your hand. I mean, you might be familiar with this, but when you turn towards your own, I think the way to do that is to turn to yourself, and then you can raise, you can look at reactions in Zoom at the bottom, and that's one of the reactions is an opportunity to raise your hand. So you could actually do that. I think the best is actually to suggest, to ask I see there's already a question on the chat box, but let me also ask, just so that we also get some kind of interaction. If you want to do that, you tell me that you want to do that. You can unmute yourself, and then you can also show us who you are, what you look like as well. So I think we can try this. Our bandwidth may allow us to do that. Okay. So I have one question, but let me ask Yasmin Amin who has raised a hand to come up and ask the question, and then I will read the other question.
Thank you very much, Dr. Fadel, and sorry that I didn't say hello when I came in.
I waited.
Completely gaga. But my question is about this اختلاط الأنساب. I mean, if they know who the father is and they insist on the child belonging to the bed, to the legal father, that would be a deliberate obfuscation of اختلاط الأنساب. I mean, he will be forever known as this person's child, and the
Yasmin?
Yasmin, you got, I think you froze. I don't know if Yasmin can, Allah, can you write to her? Because it seemed like you as a host can write to her and ask her perhaps to, maybe to reboot, and then we can listen to her. But I don't know if you caught her questions.
I caught her question up to this child will forever be known as the son, and then.
Okay. I sort of thought that, okay, let's wait until she comes in. Otherwise, then we can try.
Start with another question, and then when she
yes. Okay. All right. So this question on the chat, it's reading. I'll read it. Why would not being legally connected to the child be a deterrent for illicit intercourse? That is, what are the paternal rights for the legal father, and would that outweigh the financial responsibility, supposing this is only for the legal father? Lastly, is it being argued that this is a deterrent in 7th century Arabia specifically, or also today? That's the question.
Yeah, excellent questions. I mean, I think we have to understand that the jurists are interpreting a text from 7th century Arabia, where clearly man wanted to have sons, at least sons, right? So we see that in the report that Utbah asked his brother Saad to go get that boy, right? And we understand that in a tribal society, men want their children, particularly if they're boys, right? Because those are the source of strength and power and ultimately wealth and prestige. So I agree that that's why I say in the modern age, it's very contrary to our intuition, because in the modern period, we think, well, if a man knows that he's not going to have any responsibility for a child, if it's or not any rights to a child because it's through illicit intercourse, that's kind of an incentive to do that, because the costs of child rearing are so high in modernity compared to, let's say, 7th century Arabia. So I agree with you 100%, but I do think the logic of the rules are based on an assumption that the biological father wants the child. And so therefore the knowledge that he can't have the child is a deterrence to him, right? Because it's a punishment to him. That's the expression of the hadith. الولد للفراش وللعاهر excuse me وللعاهر الحجر, right? And so the male adulterer gets nothing, right? So whether that's true today, I think is highly questionable, right? So I gave a version of this a long time ago in Morocco, saying that because the social reality of the relationship between men and their children is so radically changed in urban civilization today, that this logic no longer works. Some of the scholars there didn't really like that, but I did make that point.
Okay, Yasmin is back. So I've got another question, but let's just pick up on Yasmin. Can you, Yasmin, can you hear us?
Yes, I can, and I'm sorry, the internet was atrocious. So my question was, I can't really wrap my head around the fact that this is a deliberate obfuscation of the nasab. I mean, the real father will vanish in even though he might be known, like in the case of Zama, and I don't understand why it's for the bed rather than for the man.
Well, again, I think for the jurists, the way they weigh these conflicting values is that you don't want to undermine the paternal relationship where it exists, because that's really destructive to the child. I mean, there's another hadith, excuse me, not a hadith, a verse in the Quran, لا تسألوا عن أشياء إن تبد لكم تسؤكم. Don't ask about things that, if they were disclosed to you that would harm you. The story, supposedly in the Sabab al-Nuzul, has to do with some sort of adultery and descent. And so a man, wanted to know who his true father was, and then found out his mother had committed adultery. So it was very devastating. So I think that's the reason, is that it's extremely devastating to the child. And also you have to look at the legal consequence. If in fact we cared about, or biological descent was admissible in these things, then the child would not have a legal father, because the adulterer can't be the legal father either, right? And so again, if you have a rule where it's always the biological father is the legal father, then you have a problem of increased litigation and conflict over this, which again, I think from a legal perspective is very damaging to the well-being of the child. So sometimes not knowing is really the best thing.
Thank you, but okay.
Okay, let's pick up another question. I see a question, but I see now the hand has gone down. Ramzi, do you still want to ask your question, or Fatima? I just saw it briefly. Fatima, did you have a question? I just saw a hand up quickly, but then I saw it disappear again. Sorry. Oh, sorry. No, I can see the hands now. So, okay, let me see it. Ask you in a way. Okay, Fatima, see that?
I don't have my hand up.
You didn't have your hand up. Sorry. Okay, Ramzi bin Amara.
Yeah. Thank you very much, Professor Taib, and thank you, Professor Fadel, for your presentation. It's really good to listen this complicated case of law, of Islamic law, listening to you, I want to raise a question related to the issue of Idda, and according to the different schools of law, and it brings me, listening to you, to an issue raised by a German scholar, Anka Bosala, who spoke of sleeping pregnancy. It means that the Idda can go between 2 to 7 years, and it is a kind of social protection of as well of children as of the parents in the case of adultery. So it means this case of sleeping in pregnancy. At that case, Anka Bosala, she compared Nigeria to Tunisia, and showed how this issue of sleeping in pregnancy is, to some extent, is a protection of the Muslim family, let's say. And it brings me to the validity of this sleeping pregnancy, because it is valid in the case of married, divorced, or widowed people. Let's say women or men, but it is only absent in the case of unmarried people. So from the perspective of Anna Posala, this issue is only raised of people who are not married, but not in the case of those who are married or divorced or widowed. And this is my point, or probably my question. So do we need this legal issue in the case when we have the issue of iddah that goes until or up to 7 years? And this is my point.
Yeah, I'm not familiar with doctrines that have the iddah going for 7 years. I'm just trying to think in my brain about how that might be possible. Presumably it would be with a woman who is perhaps a little older and has irregular menstrual periods. But even then, at least according to Malik, I believe at a certain point in time, you just start counting lunar months and you don't worry anymore about that. So that's the first time I've ever heard about iddah lasting potentially 7 years. But in general, I agree that this whole idea of the maximum gestational period has nothing to do with biology and has everything to do with protecting the good name of the mother and the interest of the child, right? Because again, being an illegitimate child is a horrific status, right? Even if you're not killed or abandoned or whatever, there are just lots and lots of bad things that result from illegitimacy.
Thanks.
Thank you. Aslam, could you come in? Yes.
Thank you very much, Abdul Qadir. Thank you very much, Professor Fadel, for a very stimulating paper. The one thing that grabbed my attention really was the fact that you don't seem to be giving much consideration to the punitive implications of determining paternity. I'm thinking here of cases where perhaps there is rape involved, and with certainty a rapist can be identified as the culprit, so to speak. And then obviously the other implication, if you're considering the punitive implications, is that adultery is something that is has a really very strict punishment. So I'm just wondering whether that might have been also a consideration for the pre-modern jurists in giving so much leeway to doubt. So those are basically the two aspects of the punitive implications that I'd like to hear a little bit more about.
Okay, let me just go with the first question first. I mean, maybe I could have expanded on criminal law, but I wasn't really thinking about that in this paper. I was just thinking about family law issues. But as I suggested, pre-modern law does not completely ignore biological facts. It gives effect to biological facts in secondary doctrines, right? So, you can't marry your sister, your biological sister, even if she's not your Shari sister, right? Etc. So I would see no reason why we couldn't use DNA evidence to establish guilt and rape, right? I don't think that's a problem. The problem just comes simply in using DNA evidence to undermine legal relationships, right? That's what I'm suggesting, I think, is Islamic law would object to. And it seems kind of trivial, but it's becoming a big problem in North America, right? Where people are using DNA evidence to undermine affiliation of children born in marital relationships. So I don't think it's a purely theoretical problem. Now, with regard to the first question, or the second question, is perhaps the leniency of pre-modern jurists in this regard related to concern about preventing application of the had penalty? Perhaps, but I don't think that's the only reason, although they're connected. So when Ibn al-Qasim says that a husband cannot initiate the la'an proceeding unless he's witnessed the act of adultery, right? Clearly, what he's saying is that the husband has to have the same knowledge that a witness and the zina prosecution has to have. But I think what's really important here is that even if he does, he doesn't get to automatically repudiate the child unless he also shows additional facts, namely that he hadn't had sexual relations with her at the same time the adulterer was, right? And that he immediately ceased having sexual relations with her prospectively, right? And so that has nothing to do with criminal liability. That has everything to do with the interest of the child and having a father, I think. Did I freeze?
Muted. Sorry, I just sorry, apologies. Mazhar, could you pose your question?
Thank you very much, Professor. I think my question is in line of Aslam's question, and Professor Fadel just aided that, but I need to I wanted to hear more explanation in terms of the consequences of this process of DNA. If we accept the DNA process to identify the biological father, the consequences, as Professor Fadel just mentioned, in terms of hudud punishment. So where we see that, can we use that to establish a hudud punishment if we do, let's say we are using the DNA, and you said from the beginning maqasid sharia, so as it's mentioned, maqasid or maslaha or any principles that do not precede the revelation or wahi, they all work under the framework of divine command or the wahi or revelation. So if we are using the DNA process to identify the biological father, so the consequences should be there. In that case, can we say this is contradicting to wahi, or no, simply we ignore that, they put the process of 4 witnesses and whatever they mention in wahi?
Okay. I think one of the points I was trying to make in the paper is that you can recognize DNA evidence for some purposes and not for other purposes based on the relevant maqsid of the sharia that's at stake, right? So I was just talking about the rules of affiliation of children. And I suggested that it makes probably really good sense to use DNA evidence to hold an adulterous father responsible for the illegitimate child of an unmarried woman, at least by holding him financially responsible, right? Because that would be consistent with the hadith that he should get no benefit, but the hadith doesn't preclude eliminating liability, right? Now, does that mean it should be admitted for everything? I said clearly no. It clearly shouldn't be admitted to allow a married man to disaffiliate a child born to his wife, right? I said that. Now, with respect to hudud, I would also say it could never be admissible to establish guilt for a hudud crime, right? Because again, we know particularly with respect to adultery, that the highest value there is satr and privacy, right? And so DNA would completely undermine that. And I think that goes to Ibn al-Qasim's refusal to allow a husband to initiate a la'an procedure, even in circumstances where the circumstantial evidence is overwhelming of his wife's guilt, right? So again, I mean, sometimes I think people who aren't, it's difficult sometimes to understand why would the law accept some kinds of evidence for certain kinds of claims, but then reject the same evidence for other kinds of claims, because we tend to sort of think in a binary way, this is either true or it's false. But that's not the way legal facts work. Legal facts work totally differently. We say this might be true for X, but it might not be true for Y. And that's just the way the law of evidence works.
Thank you very much. Sadia, Yaqub, did you have your hand up?
It was similar to the previous two questions that were asked, so I won't belabor that point further. But thank you for the talk, Dr. Fadel.
Yeah, thank you. Okay, the next we've got is Shahid Tayo.
Okay, thank you. I was just, yeah, I mean, I found it quite fascinating, particularly taking us through, you know, these legal questions, how proof, so, you know, it's also got to do with how evidence is established, how proof or truth. So on the one
It's
hand,
not very, just hold on a minute, Shade. It's not very clear, to me at least.
Oh,
you could just, yeah.
Okay, let me try again.
Yes.
You did now sound okay. So I wanted to say that on the one, so I said something to think about. I mean, I was thinking, I'm trained in social anthropology, and so it seems like you kind of suggesting that this early Islamic law contains some idea of fictive kinship. Now, this fictive kinship, I'm sure you're familiar with, like Marilyn Strathern and this whole, I think they call it not fictive, new kinship studies. And what's interesting there is that it turns around these questions of DNA, you know, a traceability, but also, you know, all kinds of like sperm donation, IVF. So basically, forms of potential kinship that are not lived, right, in a family, but that can later be established. So they deal with cases of people who have this desire to find their parents, or, you know, and then they use very like, you know, modern technology to trace this. And so in some way, you are actually, on the one hand, you're showing us that, you know, there is this kind of, there's a very similar discussion happening a long time ago, but very different to today in that truth is not as relevant as welfare. So I'm just wondering, yeah. So there's a limit. You're kind of presenting that we should accept a certain limit to certain kind of knowing, right? And then the contemporary kind of, you know, move towards, you know, scientific traceability and, you know, knowing in the sense of, you know, having some absolute facts is actually misplaced. Okay, I don't actually have a question. I just find it quite interesting. And I'm wondering, are you actually asking for a very different epistemology? Maybe you can unpack that a bit. Like, what does that mean? Because the questions that came across were very much, you know, about asserting.
Yeah, I would agree very much that in many cases we are better off not knowing. And many of the rules of evidence and procedural rules are designed consciously to keep us from knowing. And that's generally a good thing, particularly in issues related to intimacy and family, right? But that doesn't mean it's absolute, is what I'm trying to say, is that there can be certain circumstances where we can nevertheless use that evidence to establish secondary things. But that would also imply that we need to keep certain kinds of protections in place, because what we want to do is reconcile all these different values, right? So I was suggesting in the paper that you could see Muslim majority countries establishing a difference between paternity, biologically speaking, for purposes of holding fathers of illegitimate children financially liable from Shari fathers, right? But you would also need some sort of way to protect the interest of the child in that case from people knowing his status, because the status brings such awful consequences for the child, right? Likewise, you could have some kind of system where through adoption, as I was in the paper, I was arguing that you could have a system of adoption that preserves the idea of a child that is affiliated by nasab, as opposed to a child that is affiliated through convention, i.e. adoption, right? What I'm just trying to suggest is that you can use the maqasid that you find in the Revelation and in the fiqh to make positive law that reconciles all these different values and honors all these different principles in their appropriate place without making one of them absolute. and governing everything. Like, for example, truth. Like truth, when it comes to dissent, can be a very destructive principle.
Thank you very much. Very interesting. Fatima, see that? Dr. Siddharth?
And thanks to Dr. Fadel for the presentation. So 3 things. First, I'm really intrigued by the ways in which you separate out Shari parenthood and biological parenthood, because it's intriguing in terms of that terminology, that parenthood, which is itself such a biological, it has such biological origin, and the different ways in which female parenthood is differentiated from male parenthood. I mean, the ways in which it's implicated might seem quite possible for a Shari parent not to be a biological parent, but that's only possible for men. It is not possible for women. And to live easily with that distinction is, I think, where part of our challenge might lie, that we've made that distinction so easily and we're so comfortable with it. It needs to be addressed. And then a second, which I think might come to some of this, would be if you could suggest how the verses of Surah Al-Ahzab, which you referenced, may be read in inclusive rather than gender-specific terms. So I'm asking, can Aba refer to all parents, all ancestors? And if it did, then how does that change the application? If it's actually not referring exclusively to male fathers, but could be referring to all ancestors, all parents, so to speak. Then third and finally, your reading suggests that the juristic positions taken by the scholars are aimed so as not to benefit men who had illicit relations. And my question there would be, how might you read these rulings if you assumed differently? Namely, if you assume that the juristic positions were actually designed not to permit free women to benefit from an exercise of their independent sexual agency outside of marriage. And that's it.
Okay.
Thank you.
Let me just start with the last one and then go backwards. I think there's no such thing as independent sexual agency outside of marriage in Islamic law for either men or women. So, I mean, to tackle that is to say that the whole idea of
there is, for men, there is independent sexual agency outside of marriage in concubinage.
Oh, okay. Well, concubinage, can we bracket that for a second, right?
Sure.
In principle, there's a distinction between illicit intercourse and licit intercourse, right? And so there's even with concubinage, no one has absolute sexual agency. One can only exercise sexual freedom in specific forms, right? So even if you imagined a world where women could have male concubines, you would still have the same problem because she couldn't have sex with a slave that's not her concubine, right? So you'd still have the problem of illicit versus illicit sexuality. So I think that's kind of the problem that you're getting at. How do you relate if you have a distinction between licit and illicit sexual relationships, and sexual relationships have this procreative consequence, then what do you do with that consequence, right? So my reading of it is that jurists wanted to channel all procreative activity through licit relationships. And they held men to be the most responsible party for initiating illicit relationships. And so therefore, they're the ones that should be deprived of the benefit of that relationship. That's how I think they read this early precedent, right? That's my view. Now, going back to your first question, oh my gosh, now I can't remember it exactly. What if we reverse the presumption that they weren't? Go ahead. I'm sorry. Could you repeat the first question?
The first was about that we should not be comfortable with this
right. Yes.
between biology and Shari parentage.
Yes. Okay. that's true. That's only available to, that's only a problem for the case of men, not women, right? Well, unfortunately, what's the alternative rule? We know we have a comparator, the common law. The common law, illegitimate children weren't even affiliated to their mothers, right? Now, it's hard for me to believe that that's a defensible position. So it seems to me there are three possible rules. Either we always affiliate children purely biologically, in which case every kind of parenthood for the case of man is contestable, right? Whereas it's always the case with women that it will be incontestable, right? Or we can have a distinction between legal and biological, right? Or we can say it's always legal. I mean, this is just sort of the logical universe of the possible rules that we can have, as far as I see it, right? Then the second question, can we read Ahazab in a non-gendered way? I think it's hard, not simply because of the language itself, but also you have another verse that says, in ummahatukum illa allati waladnakum, right? So there's a specific verse dealing with affiliation of children to mothers. Now, of course, we can say this is all the wahid and the wahid aren't qat'iyya, and we can interpret it. But again, going back to my first response to you, Fatima, I just think there's a limited set of logical rules that could possibly be introduced here. And I just have a hard time seeing a rule that says an illegitimate child isn't affiliated to the mother is a better world.
Okay. You want to follow that up, Fatima? See, I know.
I mean, I don't know the context of the ruling which says that an illegitimate child doesn't belong to the mother at all. So
well, I'll give you an example. Up until the 20th century in the United States, if an illegitimate child, if the mother of an illegitimate child died, the child was not entitled to inherit from the mother, because he had no parents, zero, neither a father nor a mother. At least in Islamic law, he had a mother. He could inherit from the mother, right? He had the kin group of the mother was responsible for him. So there was some recognition through the mother, but in common law, there was zero, there was nothing.
With a mother is seldom controversial. I mean, it's inherent, it's biological, it happens unless there is some way in which a community doesn't know the individual's affiliation with a child with a mother is not something that is contested in the way it is contested amongst fathers, obviously.
Yeah.
So I'm not saying that, I'm not even suggesting that that would be a better thing. I'm asking that to assume that this was the juristic intention. And that is what we're doing, right? We're reading the juristic imagination. We're reading the intent of the jurists in this way. And I'm asking for an alternative reading of the juristic intent, which may not be as generous to the jurists. In fact, it implicates the jurists in a much broader sort of, I think it doesn't allow such an easy explanation. I think the explanation that is being made is a very simple explanation. I think it needs to be a lot more context specific. I think it needs to be a lot more conscious of the way biology is not universal, it's not eternal, it is very specific to time. Ideas of parenthood are very specific to time. Even the suggestion that a man would always want a child to be affiliated to them. I mean, we have the most sort of notable situation where that wasn't the case. Nabi Ibrahim lets his child into a desert because that is not going to be working for him. So people do want not to be associated with a child and to step away from a child. And that works. I mean, that's not a modern problem. That is a historical problem. To assume that all men always wanted to be associated with their children, I think that's a very flat reading of history. It comes from some very, very particular understandings of biology and parenting historically. It suits our idea of what happened historically because we like those kinds of narratives about the past, but I don't necessarily think that they always work.
Well, okay. I don't want this to turn into just a dialogue between myself and Fatima. I think her questions are very good. I'd like to respond.
That's fine, yeah.
I think part of the problem is, we might be approaching these materials in a different way. I'm not trying to make any claims, empirical claims about social history or about the plausibility of juristic presumptions. I'm just trying to figure out the best explanation for the internal logic of the rules as I find them, right? So that doesn't even necessarily require an attribution of a subjective intent to particular jurists. When I talk about maqasid, I believe these are objectively imminent in the rules as I read them. So, my basic response is, I recognize that I might be reading them completely improperly or maybe excessively generously, but I think it's a persuasive reading of the rules as such as they are. I invite other people to give an alternative reading, right?
So thank you very much. I see a few more hands up. So, but allow me to just slip in one or two questions from myself. I wanted to ask basically on two questions. I mean, one of the major theses that you're presenting is that the jurists were thinking about the interests of the child. I'm wondering if you could elaborate on it. Is this your reading of it, or is this something that comes up very clearly in the discussion as such? And secondly, I want to, okay, yeah. I mean, yeah. Okay, I think let me leave that question for you.
Okay, it is explicit in their discussions of kafala, right? Okay. And so I read the rules of kafala as supplementing the rules of affiliation. So I read them together. So we know their concern about the well-being of the child from the rules of kafala and how, serious the duties are that they impose on the caregiver. And obviously, a fortiori, that would be the role of the parent, right? Because the kafil is a substitute parent, a bad substitute, but the best that the law can come up with, right? And then you also have, maslahat al-tifl is an important concept in other areas of the law, including hadana, right? So I know that it's a value because it's emphasized in adjacent areas of the fiqh. So even if they don't say explicitly that we limit the father's right or the husband's right to start a la'an procedure to repudiate paternity, if they don't say explicitly لمصلحة الطفل, that doesn't mean that value isn't there, right? Because it's already in the law.
Okay. Thanks. Let me, I see some other persons. Let me just see if somebody else has a question. Shahid, you have a question this time?
No, I just wanted to make a comment, actually. I thought the discussion was quite fascinating between Fatima and Professor Fadel, but I just thought that I just wanted to say that, as if treating biological, paternity or biological relations as if they are just all that, as if that's the only way to understand, relation, is actually has itself quite a problematic history. So, and that's why I was referring to the anthropology. So in the late 80s and 90s, Marilyn Strathern, they actually revived the whole question of, because the idea was in a lot of anthropology was that, we Westerns, we understand, right, that paternity and family is biological, but these natives, they think, twins are birds, or they think, the whole clan is a brother, or whatever it is. So there was a whole very complicated, and also because this whole thing about relation was supposed to be this native political society, so you have an advanced political society, and so part of this whole move, to redo kinship was actually to recognize that it's always a combination of a legal and biological, or social and biological, and then exactly how that works. It seems to me, as much as we'd like to believe that, I was just thinking that, women also might be liable to abandon their children. Of course, the possibility of that is different, but after the fact, they would that can also arise. It can't be as if there's a pure biology which puts the claim more on one side than the other.
I want to just respond to this idea of abandoning a child. Repudiation is not abandonment. Abandonment is an empirical fact that exists or doesn't exist or can be in a spectrum. Repudiation is a legal relation, is a legal judgment. So in Islamic law, a mother can never repudiate the affiliation of a child that she's given birth to. Whether we think that's a good rule or a bad rule, that's the rule, right? Same thing, a father, let me take that back. A father, however, is given a very limited grounds to repudiate a child. So this is a legal judgment. It has nothing to do with physical proximity or love or care or anything like that. I'm just talking about the legal rules. We can, the legal rules might be awful, but that's just what the rules are. A woman, unlike contemporary United States or Canada, a mother in Islamic law cannot say, I disclaim all my rights as a mother. And in fact, this is a big problem. Canada sometimes does not allow the adoption of kids from Muslim countries, Canadians to adopt Muslim kids and bring them to Canada on the grounds that in Islamic law, a mother can never repudiate her status as a mother, which is a requirement for an illegal adoption in the West. Even though, she left him at the door of a mosque and, whatever, right?
Interesting. Aslam, please go ahead. I think we'll make that the last question and then we'll close. I think it's coming close to an hour and a half. So thank you very much. Aslam, please go ahead.
Thank you very much. Once again, I think what the most interesting aspect of all of the points that are raised in the paper for me, perhaps, is this whole issue of li'an. And, the issue of when there's no clear evidence of adultery and then the wife or the husband then taking this oath that they, invoke God's curse on them if they are incorrect. To me, this introduces, the idea of a deferment of judgment. But it's very hard to see this in terms of a materialist epistemology where we just look at things in terms of, our worldly secular existence. So I'm just wondering what you think about this, Professor Fadel, in terms of, the maqasid al-Sharia. When we introduce the idea of a deferment of judgment, not pronouncing a judgment in this world, in the expectation that there is a greater judgment in the hereafter. And this also has some implications in terms of, the punitive cases that we know of. I'm thinking of the Al-Ghamidiyya, the woman that, insisted that she be held accountable for punishment because it was a cleansing. So it was a case of perhaps, facing an immediate harm in order to defer a greater harm in the hereafter. I'm wondering whether, these considerations also play into how we determine what is the maqasid, because as you said at the beginning, this is something that is an inductive process, something that is done by istiqra.
Right. So I think, again, it goes back, I think this is reflected in the rules that we see, at least in the Maliki doctrine, where there's only one very narrow circumstance in which the husband is obligated to bring a la'an proceeding, namely when he knows with 100% absolute certainty that there's no way the children could be his. So they're going to Yasmin's initial question. If the facts are already known in such a way that it is impossible that the child could be affiliated to the father, then there's this obligation to bring the action. But everywhere else, right? No. And this goes back to the idea that I think they're suggesting about the judgment, that the true justice, true judgment is in the next life, that we should only find out truth to the extent that it affects a legitimate worldly interest of ours today, right? But we shouldn't go beyond that. There's no reason to know the truth about whether or not this person engaged in a grievous sin. It doesn't concern us, right? Only if it concerns us in some material, tangible way do we need to know the truth about it. And most of the time, the vast majority of times, we have no legitimate reason to know. I think that's what we see in the rules about la'an. Again, even if you've seen your wife committing adultery, better to just divorce her and not bring a la'an proceeding.
Thank you very much. I have a short questions and a comment, but maybe you could just use it. First of all, I want to thank you for sharing this wonderful, at least presentation in terms of thinking about how do we think about the a set of texts and then juridical rulings which are sort of framed within a broader sense of the maqasid. The comment or the question that I have, and you don't have to necessarily refer to it, but I was struck in the beginning when you're suggesting that one perhaps needs to think about maslaha as flourishing, and so I think that has broad consequences of how we think about maqasid, but it ties up with a book that we've been reading in our own circles, Mizanul Amal of Ghazali, who uses the word sa'ada. And do you see the sort of and I think that the ethicists and some of the philosophers, drawing on Aristotle, were sort of using this term, of sa'ada as well. Do you see the relationship between the two? And I think that that's perhaps a really interesting way of actually, expanding the scope or thinking about maqasid as well.
Absolutely, absolutely. I think maslaha is a theory of happiness. Properly considered. So Shatibi explains, I think it's very interesting. He says that the reason we know that divine law is intended to secure our well-being is based on experience, because we see that people who live their lives in accordance with the Sharia live good lives, right? Whereas those who don't live bad lives. So it's interesting. He doesn't do the circular argument that you see among some modern jurists who say that, yes, the Sharia is all masalih, but the masalih is completely internal to the text, so you have no right to understand how it applies in the real world. Whereas Shatibi tests it against empirical experience and says, no, we know that this is the maqsood of the lawgiver because we see through our experience that living by it produces happiness and ignoring it produces unhappiness. So I think it is the equivalent of eudaimonia or whatever that Greek term is.
Yes.
It's not simply, it's very wrong to believe it's utilitarian in the way that some people describe it.
Okay. So I thank you all. I thank you first of all for sharing this with us. I think you've raised, presented as a sort of fascinating model and example of thinking about the maqasid and also tackling some, really modern questions, thinking about science and particularly through DNA. I'm sure that you've raised a whole lot of questions as we saw in the discussion, and I think we will continue to think about this and reflect on this. I really appreciate the opportunity, the time that you have spent with us. So thank you very much. At the same time, I also want to thank everybody else who is being part of this discussion. I mean, I think thank you for being here with us. I hope to see you next month. So we'll send you the invitation. What we are thinking of our next seminar is going to be something very closely connected with yours. It's about thinking about science and how that sort of challenges our way of thinking about Islam, particularly about Islam in general, but also thinking about the whole scientific project, or the scientific worldview, and how Muslims respond to it, and how that relates to various issues, including Islamic law. But this is going to be given to us by Anwar Mal, who is a biochemist, a retired biochemist at the University of Cape Town, and he's been talking about the relationship between Islam and science as a kind of a hobby over a period of time, and I've asked him to present a lecture on that. So thank you again, Mohammad, for joining us. All right. Okay. So we could have told you now, let's go for dinner in Cape Town, but you'll have to do a rain check with us.
Inshallah.
When you see you, inshallah.
Inshallah. Okay. Thank you for all the questions and your careful attention to the talk. Thank you.